Hi and welcome to the latest episode of Coffee and Counsel. I'm Naomi Cope, an associate solicitor in the litigation team, and I'm talking to you today about defamation. Some say that all publicity is good publicity, but what if someone has said or written something about you or your business and it's harming your reputation? Business owners spend so much time and money building their brand, and all that hard work could be undone with a misleading article or an untrue statement. Most people do not enjoy reading bad things about themselves. When untrue statements are made, it can affect your finances and even your well-being. Defamation law is an area of tort law which aims to protect individuals and businesses from false statements that harm their reputation. The law is primarily governed by the Defamation Act 2013. The Act defines defamation as a statement that causes or is likely to cause serious harm to the reputation of the claimant. There are two types of defamation: libel and slander. Libel is when the false statement is written, for example in a social media post or a news article. Slander is when the false statement is spoken. Under the Act, a claimant has to establish a number of things to bring a claim for defamation. The first, the statement must be defamatory. The court will consider how the statement is understood by those who read or hear it, given the words their natural and ordinary meaning, and whether the statement lowers the claimant's reputation in the eyes of a reasonable person. If this statement adversely affects the attitude of people towards the claimant, then the statement is likely to be defamatory. The second, the statement identifies the claimant, whether directly or indirectly. This can occur through explicit reference by name or descriptive details that allows readers or listeners to infer the claimant's identity. If a reasonable person would interpret the statement as referring to the claimant, then this element will be established. The third, that the statement was published. The statement must have been published or heard to establish this element. If the statement is communicated but fails to reach a third party, it cannot form the basis of a defamatory claim. And the fourth, the statement has caused or is likely to cause serious harm to the reputation of the claimant. A statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. Online platforms have made it easier for defamatory material to be published and widely shared, amplifying the harm caused and extending its reach globally. The court can consider the platform's audience size and its content to assess serious harm. Technology has advanced so much that ignoring the defamatory statement and hoping people don't see it is rarely a suitable option. Word of mouth spreads much easier when people are available at the press of a button. So what steps should you take to protect your reputation following a defamatory statement? An action for defamation is a personal action, meaning that only the individual or business which has been defamed may bring proceedings, save for limited exceptions. Anybody involved in the publication of defamatory material can be sued. This could be the author, editor, producer, publishing company, or website owner. Before proceedings are issued, the court will expect the claimant to have complied with the pre-action protocol for media and communications claims. The aim of the protocol is to enable the parties to explore the early and appropriate resolution of the claim. This entails the claimant sending a letter of claim on the defendant, which should include various information which is sufficient for the defendant to understand the claim against it. The defendant will be invited to provide a response to the letter of claim as soon as possible, possibly and usually within 14 days. The court will also expect the parties to consider alternative dispute resolution, ADR. ADR is not compulsory, but a party's refusal to engage with it could lead to cost consequences. If following compliance with the protocol, a satisfactory resolution cannot be achieved, the claimant is able to commence legal proceedings. The Act provides a 12-month time limit from the date of the publication of the statement to start court proceedings, with limited exceptions. Outside of the courtroom, there are other things you can consider to protect your reputation. You could publish a response to the defamatory statement, putting the record straight using facts and letting others know the statement is misleading or untrue. You could use it as an opportunity to publish material so that the platforms are filled with positive news about you or your business. They do say when life gives you lemons, it makes lemonade. A notice and takedown letter can be an effective solution to having the defamatory statement removed promptly. This letter can be sent to the publisher of the material. For example, this could be a social media platform like Facebook, or to the internet service provider, putting them on notice of the defamatory statement and formally requesting that the material is removed and not republished. Even if the claimant issues legal proceedings and can successfully establish the four elements discussed earlier, a defendant may have a defence to a defamation claim. There are a number of potential defences. The defendant will have a complete defence if it can prove that the statement is substantially true. If the statement represents a sincerely held opinion, rather than being presented as a factual claim, then the defendant will have a defence to the claim. Certain statements are safeguarded under absolute or qualified privilege, including those made during Parliament sessions and as part of a fair and accurate public interest report. The defendant will have a defence if it can show that the publication is justified as it serves the broader benefit of the public. What is in the public's interest is potentially very wide, but it needs to be more than simply newsworthy. Intermediaries, like internet service providers, can claim this defence if they unknowingly disseminate defamatory material. Once the battle has been won, remedies in defamation cases generally include the following. Damages. The claimant may be awarded damages to remedy the claimant's distress caused by the defamatory statement and/or any loss following the statement. Undertaking. The defendant may give a legal promise not to publish any further similar defamatory statements. Injunction. Interim injunctions are rarely granted during the course of legal proceedings, but a final injunction may be granted after trial to restrain further or future publications of similar defamatory statements. The court has the power to order the defendant to publish a summary of the court's judgment. The court does not have a general power to require the defendant to correct the defamatory statement or declare the statement to have been false. If you have any concerns about an untrue or misleading statement which has been published about you or your business, then the team are here to help.